Judiciary, structure and role. The Supreme Court, historically, when I've talked about it, has been one of the more exciting topics in this class. There's been a lot that has been happening in America that has made this a little bit less of a sexy topic to talk about because there's so much else going on. It seems like paying attention to this body of, let's be honest, aging legal scholars is not quite as interesting as perhaps it was immediately following the Dobbs decision. But you and I and all of us together will soldier on through it. So, I assigned a reading. It's a 2001 reprint of a classic piece from the scholar Dahl that he writes in 1957, very ahead of his time, writing about the Supreme Court. Before we dive into it, do we have any questions on the reading? No questions? All right. You know what's next, then I turned it back on you guys. What's Dahl's argument in this piece? So he argues that the court is a policymaker. It's not just a legal arbiter. He says that they regularly make policy decisions. What is a policy decision? I mean, yes, but it's choosing between controversial alternatives when a policy question or when a statute, precedent, or constitutional text are too vague to tell them where they should actually go with the decision, right? They fill in the blank, and they are, in effect, making policy. Great example of this is segregation or economic regulation. These things aren't stipulated in the Constitution, so the Supreme Court often has to step in and fill in the blanks. He argues that the court is a political institution. A political institution could be like Congress. Those are people who are elected and they have political beliefs about things and they make decisions based on their political beliefs and the political beliefs of their constituencies. He argues that the court's classic model is one of this like legalistic impartiality, right? That they are impartial judges that don't have ideology and that lends them legitimacy. But in fact, they are a political institution and have to make choices based on politics. Getting into the point of our friend over here, the court aligns with dominant political coalitions. Now let's trace this back. Why they might want to align with dominant political coalitions? Well, we've talked ad nauseum about the appointment process. Justices are chosen not just because they are these concrete walls, these brick slabs of, I know the law and I execute the law. They're chosen because presidents like what the choices they might make are in the office of a Supreme Court justice, right? That they are also reflecting the political prerogatives of the Senate in the appointment process. Because when a president chooses a nominee, they have to be approved by the Senate. So, in part, the nominee has to align with the Senate enough that the Senate will pass them through. There's this idea that the Supreme Court, in addition to being legalistic and non-ideologically driven, is a counter-majoritarian actor. By that, I mean they preserve the rights of the minority, but in fact, in order to retain their legitimacy, because they're influenced by politics through the nomination process, and once they're actually on the bench, they more often than not update their beliefs and their decisions to reflect the politics of the time. Dahl cites a piece of writing early in the piece from Justice Frankfurter, my favorite justice name, where he talks about the mood of the public and how the court has to reflect those moods, basically the vibe of what's happening. And this leads to the court legitimizing, but rarely blocking, the goals of the majority. Rather than consistently defending minorities against tyranny, even though some Supreme Courts, like under Chief Justice Earl Warren, did do that, cite cases like Loving v. Virginia, it's not what they generally do. For example, the court has over time started opposed to the public in these areas and come into adopting the public's view about policies like income tax, child labor, or even New Deal programs under FDR. The court initially resists the public majoritarian sentiment on these things, but eventually, in order to retain the legitimacy of the institution itself, they then change their opinions to match with what the majority believes. Supreme Court justices are not heroes, they are politicians. Let's run over to the Constitution corner, shall we? What is Article 3, Section 1? Yes. What else? Under what conditions do they hold their office? Yes. What does good behavior mean? Does it mean that they're just like really good boys and girls and like, help grandmas across the street? They don't do anything illegal. They're tenure protected offices. Judicial power is in one Supreme Court, and Congress can create lower federal courts. Supreme Court justices serve during good behavior. That means they don't need to be elected, and they can't be fired for political reasons. What is Article 3, Section 2 then? It's defining the scope of federal judicial power relative to lower courts. It grants the Supreme Court original jurisdiction, and we'll explain what that means, in cases involving ambassadors in states and giving it appellate jurisdiction in most other areas of the law. What is Article 3, Section 3? This one's a spicy one. It's the only section of the Constitution that actually defines a specific crime. Treason. What's the 11th Amendment? Limits suits against the state. This comes out of a case called Chisholm v. Georgia in 1793, in which one individual from one state tried to sue another state. And as we talk about later in the lecture with rules of access to the Supreme Court, you can't really do that. If I'm in Pennsylvania and I want to sue the South Carolina state government, I'm not really an aggrieved party by anything that they're doing. Let's dive into it. Judicial branch. We're going to start with a fundamental lie. Judicial independence. Article 3 establishes federal courts as distinct institutions from the other branches and also other courts. We already established that judges are given life tenure during good behavior, so they can't be fired for political reasons. You can't just fire Justice, Ketanji Brown Jackson because you don't like her politics on things. You can't fire Justice Neil Gorsuch because of his politics on things. Their salaries are protected from reduction from Congress, so you can't really lower their pay. So Congress can't come in and punish them financially for anything that they do in their rulings. Whether or not this is an effective stick versus a carrot is up for debate. I mean, Supreme Court justices make a lot of money through, even though they're not really supposed to, donors, special favors, and speaking engagements. These safeguards reflect a ostensibly deep commitment to judicial independence, that courts must be free from politics and political retaliation so they can fairly apply the law to the case at hand. Yet, in practice, the courts aren't ever completely separate from politics, obviously. Presidents, as we've established, nominate things. The Senate moderates their behavior through the confirmation process, and the public always judges legitimacy. I mean, I don't know if you guys remember the uproar after repealing Roe v. Wade and their decision in Dobbs v. Jackson, but there was a massive public outcry about that. You guys certainly don't remember the public outcry after Citizens United the FEC. So courts serve three essential functions. At their most basic level, courts settle disputes, obviously. Those are between individuals, between an individual and their government, or sometimes between governments. Beyond dispute resolution, courts also interpret law. We have a common law system, and I'll explain that a little bit later. They clarify vague statutes and apply them to new situations or the context at hand. Their most powerful function for the court is enforcing the Constitution. And that's ensuring that the government and actors within it don't violate the fundamental principles of our founding document. That last role makes them this kind of lofty guardians of liberty, but it also places them in direct conflict with the elected branches. So you have this branch as the arbiter over all of the decisions of the government. But unlike the other branches of the government, This entity is not elected and therefore does not face the same direct public accountability as the others. Now, I outlined three main types of law in this slide. Depending on who you read, and certainly when you get to law school, there will be a lot more here, or sometimes just the two that I've outlined in this figure here. But I'm going to talk about it in terms of three kinds of law. Courts handle first criminal law, and this is the most straightforward. It involves violations of the public order, with the government prosecuting individuals accused of crime. For example, you commit a murder, that is a crime, the government will prosecute you for it. Next, you have civil law, and it involves disputes between private parties. These are debates over contracts and property, and if you go to law school, and I'm not going to explain this here because I don't super understand it myself that well, torts. And finally, related to the Supreme Court, you have public law, which concerns constitutional and administrative questions, cases where the government itself is a party, such as challenges to regulations or even civil liberties cases. Public law is especially important in the American context here because it connects the courts directly to governance and, as Dahl said, policymaking. This is the area in which they are exercising their policymaking powers. I encourage you to revisit this slide if you want to know the difference between civil and criminal law here, because I think it does a really good job, this figure, just breaking down aggrieved parties and the like. Just know that the party involved in public law is the government. As I hinted out, the American legal system is built on a system or a conception of law called common law, where past decisions shape future rulings. So when you hear about the legal canon of a certain issue, the legal canon related to civil rights or gay marriage, this is what they're talking about. Past decisions influence the future. This is through a principle called stare decisis. Ignore my Latin pronunciation. I apologize if you were a devout Catholic or, I guess, like archaic poetry or something. Basically, stare decisis means let the decision stand. And courts generally follow this principle to ensure stability and predictability in their rulings. That's basically legal precedent. Precedent is what came before. So, you have a case, that becomes legal precedent, Supreme Court or some court sees that precedent and they say stare decisis. Regardless of my own opinions on this or my own ideological commitments, I think that continuing with the legal canon established before is the most important thing here. That was a position that Justice Sandra Day O'Connor took a lot of the time. While Sandra Day O'Connor herself was a conservative, she was appointed by Ronald Reagan, she often would side with the more liberal side of the court simply because she believed upholding the precedent from the Warren Court, regardless if she disagreed with it or not, was more important to the continuity of American government than the potential chaos that comes from continuously reversing precedent. And still, as a note, precedent can be overturned when deemed wrongly decided. The classic example of this that you guys should probably know about is Brown v. Board of Education overturning Plessy v. Ferguson. You all should be more or less familiar with that case already. I'm not going to go into that. There are different types of courts, and the federal judiciary is hierarchical. It is not diffused horizontally, it is vertically hierarchical. First, you have trial courts or district courts, and these handle fact-finding and initial rulings. This is the vast majority of courts across America. Next, you have appeals courts, and we'll talk about different forms of those. For example, circuit courts, which are described in this figure here. There are 12 federal circuit courts of appeal, which review trial decisions for errors of law, but not necessarily facts. So, was the decision decided correctly based on the interpretation of the law, not necessarily based on the facts of the case? And of course, at the top is the Supreme Court, which selects cases raising major constitutional or federal questions. The Supreme Court is the flashy one that gets in the headlines a lot. It's the most visible one. But it might surprise you to know that the Supreme Court hears less than 100 cases a year, and that number is shrinking every year too. They're hearing less and less cases. Of the some 4,000 to 6,000 cases that are sent up requesting review at the Supreme Court, they only choose about 80 of those. Most of the time, what they just say is, the Circuit Court of Appeal, they got it right. Here is a breakdown of the hierarchy of the US court system. So you have two legs to it, the federal system and the state system. This is generally true. Some states have variation. I'll get into that in a second. The federal system, you have district courts, appeal to the US Circuit Courts of Appeal. Then you have a request for review by the Supreme Court, and only then does the Supreme Court potentially decide to take that case. State system roughly mirrors here. Sometimes there's a state Supreme Court. In the case of Pennsylvania, my home state, you have a Commonwealth Court that is a different thing, and a state Supreme Court. Other states have more archaic bodies coming out of their state constitution, but that also potentially leads to a request for review, and then the Supreme Court at the top. Speaking of those head honchos, here they are, the Supreme Court of the United States. It currently has 9 justices, 1 chief, and 8 associates. The Chief Justice is John Roberts, right here, who was appointed by George W. Bush. That is Bush number 2. There are currently a conservative majority on the court, made up of Samuel Alito, who is largely considered to be the most conservative justice, but Clarence Thomas sometimes gives him a run for his money in terms of conservatism. Then you have the 3 Trump appointees, which are Amy Coney Barrett, who replaced Neil Gorsuch, who replaced Antonin Scalia, and Brett Kavanaugh. Then you have the 3 liberal justices, 2 of whom are Obama appointees. That's Justice Sonia Sotomayor and Justice Elena Kagan. And then the 1 Biden appointee, Justice Ketanji Brown Jackson. So there are 9 justices, 1 chief and 8 associates. After cases are argued, the justices meet in conference, and the senior justice, who is in the majority, that is the justice who has served the longest on the court. The more senior justices are Thomas, Alito, Roberts, and then after them, Sotomayor, Kagan, followed by the Trump appointees, and then the most junior justice is Ketanji Brown Jackson. The senior justice on the majority decides who writes the opinion of the court. This assignment power is significant. It allows the chief, if they're in the majority, to shape doctrine by choosing who writes. That is a political decision often that the court will make. It was a big deal that they had Samuel Alito, the most conservative justice, write the Dobbs v. Jackson opinion. It was also a big deal for Justice John Roberts, a conservative justice, to write the opinion for the case that I can't remember the name of it right now, that decided that Obamacare was constitutional. It was kind of an olive branch showing that even though I'm a conservative justice, I'm on the majority. It is the opinion of the court and the majority that the Chief Justice is writing this. It's important. The size of the Supreme Court is set by Congress. It is not in the Constitution that it has to be 9 justices. The Supreme Court has ranged in size from as few as 6 justices to as many as 10. This is what allows for the potential of court packing. Famously, FDR threatened to do this when passing New Deal issues. Basically, the Supreme Court kept striking down New Deal programs because they said they were unconstitutional. Specifically, 4 justices that I can't remember their name on the court at the time that were called the 4 Horsemen, as a reference to the 4 Horsemen of the Apocalypse. And so FDR threatened to pack the court by putting a bunch more justices on that agreed with him. There were debates under the Biden administration that he should do this as well because there was a conservative supermajority on the court of 6 conservative justices to 3 liberal justices. Jurisdiction is the authority to hear a case. State courts handle most disputes, from traffic tickets to family law, that's divorces and the like. Federal courts hear cases involving federal laws, treaties, the Constitution, or even disputes between states. The Supreme Court has limited original jurisdiction. That's mainly state v. state cases, and this is Article 3, Section 2. Remember that. It's probably on the test that defines their original jurisdiction. But most of its work is actually appellate jurisdiction, which is reviewing lower court decisions. Note that most cases stay in state courts. Remember, the Supreme Court is only hearing about 80 cases a year. Even so, the Circuit Court of Appeals and the like, those hear shockingly few cases relative to the vast number of cases that are brought before them. This is also a somewhat helpful figure, I did not make this one, shows various contributing factors to what makes up the concept of jurisdiction. And a lot of these are also covered when we talk about rules of access for the court. Federal judges are appointed by the president and confirmed by the Senate, obviously. Traditionally, senators from the nominee's state have strong influence in this decision-making process, a practice known as senatorial courtesy, although the increasing polarization and divisiveness of these appointment hearings ends up making this old practice seem a little antiquated and much less important. The Senate in 2013 used the nuclear option, eliminating the filibuster, for lower court judicial nominees, so it no longer required 2/3 majority vote to appoint a lower court nominee to the federal bench. And in 2017, Congress used the nuclear option on all Supreme Court nominees, so it no longer takes a 2/3 majority to appoint them. That was to get Neil Gorsuch in at the time, but helped individuals like our very surly-looking friend there, Brett Kavanaugh. I've talked about judicial review before. It's an important power that the court has, and it's the power to declare laws or executive actions unconstitutional. This is probably one of like 3 or 4 cases I will require you to know. It'll be on the study guide for the midterm exam, don't worry. But it's established in this case called Marbury v. Madison in 1803. The authority to use judicial review isn't spelled out in the Constitution, but at the time, Chief Justice Marshall argues that simply by having a written Constitution, it implies the power of judicial review does exist. If you have a written code of conduct for your nation, you have to have someone there who's the parliamentarian, who's going to actually make sure that people are following that code. The practice of judicial review is used more selectively than you might think. Not every single case, in fact, the vast minority of them that comes to the Supreme Court are not over these lofty questions of do we declare a congressional act unconstitutional? Rather, they are more mundane affairs than that. When it is used, it is a somewhat big deal. But generally, the court defers to their other branch counterparts that actually are in charge of legislating, the legislative branch, and then, to a degree, the executive branch through executive orders, because it grants the Supreme Court legitimacy and also helps reinforce the legitimacy of the other branches. They only intervene aggressively when transgressions are particularly egregious. Think of Brown v. Board, Roe v. Wade, or when they absolutely need to in the case of Bush v. Gore that was deciding the 2000 presidential election. I know that was before all of your time, but it was a big deal at the time. I've been talking about rules of access a lot. Trust me, this picture is going to make sense in about 3 minutes. Not every dispute reaches court. Cases have to meet certain requirements. And these requirements are rules of access. For instance, there must be a real case or controversy, not a hypothetical one. If there is something that might happen, the court can't take that up. It has to have actually happened. Plaintiffs have to have standing, meaning they're directly affected. If something impacts my friend John, I can't sue on his behalf under most circumstances because I haven't been harmed myself. Cases can't be moot, meaning that it's already been decided by some other means, either through arbitration out of court or through a prior court case. And finally, cases have to be ripe, ready for judicial resolution, and not premature. If there is an act of Congress that passes in some state legislature, and it seems like it's going to hurt a lot of people, and then you immediately sue them and you bring that case to the Supreme Court, it's not going to be ripe yet because there hasn't been actual injury that has happened yet. There has to be injury. There are, going back to the very important business of the Supreme Court, competing philosophies within the judiciary on how the judiciary should act and what its scope of power should be. I frame this through a major debate between two schools of thought, though there are a lot of subsidiary schools of thought about this, and also adjacent ones that don't necessarily fit into this classification. But for the sake of our class, we're going to define two judicial philosophies that kind of define the debate over what the Supreme Court should do. First, you have judicial restraint, which holds that the court should defer to elected branches unless there's a clear constitutional violation at hand. Basically, the Supreme Court should not act unless it absolutely has to, and when it does, it should only say so much. On the other side, you have judicial activism, which accepts that the court might need to act more aggressively to protect the rights of the citizens or to correct injustices, regardless of if we view that violation of the Constitution as particularly egregious or not. In practice, these terms are politically loaded, and what one side might call restraint, the other might call abdication of authority, what one side might call activism and undue interference, the other side might say is courageous. Ideology influences the outcomes here for both of these. Particularly people in the judicial restraint camp might argue that they're adopting this legalistic view of the Supreme Court, that it should only be the arbiter of these cases from an impartial point of view. That in and of itself is an ideology that will impact how those cases look when it comes out. They are being somewhat hypocritical when they adopt that. Not to say that judicial activism is inherently good either, there are problems with that as well. And this is mainly couched in this debate of law and politics. You cannot have one without the other, despite what some people might want. I'm going to take some time to actually discuss these two things here on the screen. They are both books from former Supreme Court Justices Stephen Breyer, who retired, and Antonin Scalia, who passed away. But they're both really interesting writings on how they believe the Supreme Court should act. Matter of interpretation, with Antonin Scalia looking at you very, seriously on it, is his treatise on judicial restraint and textualism, arguing that we should follow the text of the Constitution specifically and go no further. What this means is that there are no such things to him as implied rights, like a right to privacy, and you cannot interpret the Constitution as a fluid, evolving document. Justice Breyer, who I believe he wrote this while he was still a Supreme Court justice, comes back and he says that is a very unrealistic way, an incorrect way of viewing the Constitution. And this just goes to show that these two justices are having this debate while actively making choices about the future of the country while they're on the court. Antonin Scalia wrote the first edition of this years and years before he passed away, and it influenced so many legal scholars out in the world today and also currently on the Supreme Court. Amy Coney Barrett is a textualist in the Scalia sense. She was highly influenced by him. It's an evolving way of viewing the law, and it changes over time, and these debates happen internal to the institution itself. So I would argue that Dahl is correct. His view that ideology influences these candidates, that it is a political institution, I would argue is a correct one, even if a justice is arguing judicial restraint here, simply because that itself is an ideology.